Hello and greetings. My name is David Moore, Vice President for Legal Affairs, Legal Principles supporting the freedom of peaceful assembly. The starting point is the Universal Declaration of Human Rights. In Article 20, the Universal Declaration affirms that everyone has the right to freedom of peaceful assembly and association. The International Covenant on Civil and Political Rights in Article 21 provides more detail. The right of peaceful assembly shall be recognized. No restrictions may be placed on the exercise of this right other than those imposed in conformity with the law and which are necessary in a democratic society in the interests of national security or public safety, public order, the protection of public health or morals, or the protection of the rights and freedoms of others. Those principles outlined in the Universal Declaration and the International Covenant apply to most UN member states. Most countries in the world have signed on to and ratified the International Covenant. So that principle is binding in most countries. One interesting thing to note is the interrelationship between peaceful assembly and association. They're mentioned in the same phrase in the Universal Declaration, and repeatedly in international law, we see it recognized that the freedoms of expression, assembly, and association are inextricably intertwined, serving essentially as enablers of each other. Now, it's important to note in looking at the International Covenant, the language from the International Covenant, when an interference can be justified. The International Covenant lays out a three-part test, and we'll be coming back to this test repeatedly in considering national level legislation affecting peaceful assembly. So the three-part test includes in conformity with law, legitimate government objectives, and necessary in a democratic society. In other words, an interference with the freedom of peaceful assembly can only be justified where it is 1, in conformity with law, 2, intended to further legitimate government objectives, and 3, necessary in a democratic society. It is a cumulative test, that is, an interference can only be justified where it meets all 3 of those conditions. Oftentimes, the government will seek to justify interference based on national security, based on public order, based on the protection of health or morals. But the trick can be the necessity clause, which essentially triggers a proportionality test. The interference has to be the least intrusive means available. And it is on that third prong of the test that we see most of the arguments under international law about whether a national legal measure is justified or not justified. However, it is important not to forget the first 2 prongs. In conformity with law means that the interference must have a formal basis in law, and it must be sufficiently precise to enable an individual to assess whether or not his conduct would be in breach of law and to foresee the consequences of such a breach. The legitimate government objectives are limited to the 4 grounds listed in the International Covenant, Article 21. And then, again, the third test, necessary in a democratic society. Now that we have the basic framework defined in the Universal Declaration and the International Covenant, let's consider some of the specific issues relating to the freedom of peaceful assembly and how it is regulated. A threshold point, of course, is what we mean when we talk about peaceful assembly. How do we define peaceful assembly? referring to a recent report filed by the UN Special Rapporteur on the rights to freedom of peaceful assembly and of association, Mr. Mainakiai, a report that was published in May of this year, May of 2013. Peaceful assembly is defined as follows: an intentional and temporary gathering in a private or public space for a specific purpose. This would include most things that we think of when we think of peaceful assembly: demonstrations, public gatherings, meetings, strikes, processions, marches, rallies, and so forth. How broadly encompassing is the right to freedom of peaceful assembly? It's important to recognize that it protects and applies to all individuals within the territory of the state at issue, all individuals within the jurisdiction of the state. That means it embraces citizens and non-citizens both. In many countries, the Constitution or the national level law, or both, will restrict the freedom of peaceful assembly only to citizens. That is a clear violation of international legal principles. The right protects non-citizens as well, and that includes stateless persons, refugees, foreign citizens, asylum seekers, migrants, and even tourists. Minorities, women, children, human rights defenders, and other categories of vulnerable persons are also clearly protected under the right of freedom of peaceful assembly. The right also, importantly, applies to both natural persons and legal entities. That is, registered associations and unregistered associations have the right to freedom of peaceful assembly and may act as organizers. That is a point that has been stressed repeatedly by varying UN special rapporteurs in interpreting the right to the freedom of peaceful assembly. So it's a broadly embracing right that applies to all individuals within the territory. Next, let's consider the presumption in favor of assemblies. An assembly should be presumed lawful and not constituting a threat to public order. And indeed, the law at the national level in a country should expressly recognize this presumption. No prior authorization should be necessary in order to exercise the freedom of peaceful assembly. There should be no requirement of advance permission by the government in order to exercise the freedom of peaceful assembly. And again, this presumption in favor to fully comply with international legal principles should be expressly recognized at the national level. That being said, there are in many countries requirements relating to advance notification. Advance notification may indeed be justified under international legal principles by a state's duty to protect public order, public safety, and the rights and freedoms of others, especially where a demonstration or a procession is anticipated in large numbers. There may be a reasonable reason, a legitimate government interest in requiring advanced notification. And indeed, advanced notification, which is an interference with the freedom of peaceful assembly, nonetheless has been deemed to be justifiable by the UN Human Rights Committee and also by various regional courts, regional human rights courts, including the European Court on Human Rights. So what then is advance notification? What are the requirements that go into advance notification, the procedures that relate to advance notification that are deemed acceptable? Let's consider a few. Advance notification is generally acceptable if authorities are required to provide a prompt response. If an assembly may proceed where the organizers have received no response or a delayed response, and where an exception is made for spontaneous assemblies. We'll get to that last point in a few minutes. However, if the procedures relating to advance notification are so burdensome or onerous that they create a real impediment to free association, then the requirement is problematic. If individual demonstrators are required to provide advance notice and not simply the organizer, the requirement is problematic. Essentially, if advance notification amounts to a requirement of permission, then we have a problem. And again, we go back to this presumption of being able to organize and stage an assembly without prior permission. Notification, however, is something else. And let's look at what the notification procedures may include. First, it's important to note that notification procedures should generally only be required for large assemblies. A 3 or 4 person assembly would normally not require a notification. The specific threshold that constitutes a large assembly is best determined, of course, by law, but should be set at a reasonable level. In terms of the timing, the UN Special Rapporteur has noticed that it should be a maximum of 48 hours advance notice, and that should give the government sufficient time to be able to plan accordingly. That a single notification should be required to a designated primary authority and not a requirement of notification to multiple authorities. In terms of the content of the notification, it typically could include the date, time, duration, location or march itinerary, as well as the name, address, and contact information of the organizer. Those are legitimate requirements. Anything beyond that, such as predicting the number of participants, anything that relates to the content of the message is likely to be problematic under international legal principles. In addition, the notification process should be free of charge. There should be a receipt provided by the regulatory body acknowledging timely notification. If there are any limitations that the government seeks to impose, there should be timely and fulsome reasons for those limitations given to the organizer and an opportunity for an expedited appeal process. And again, if you have an advance notification requirement of 48 hours, then that appeal process needs to happen very quickly. Finally, the failure to notify, the failure to comply with the notification requirements should not automatically result in a dispersal of the assembly or administrative or criminal sanctions against the organizers. Again, there should be a recognition of spontaneous assemblies. Spontaneous assemblies are a clear exception to the notification requirement that should be expressly recognized by law. And it generally will apply, that is, the exception would generally apply where the giving of notice is impracticable or where there is no existing or identifiable organizer. A spontaneous assembly may take place immediately after a certain event occurs where it is simply not practical to have given 48 hours notice or to have complied with the notification procedures. So again, the law should expressly affirm that ability and not hold people criminally or administratively liable for the failure to notify. Now, moving on to time, place, and manner restrictions. The government may seek to impose certain limitations on an assembly. There may be time restrictions, there may be place restrictions, and there may be manner restrictions, which might refer to the use of loudspeakers or other kinds of audio or visual equipment. It's important to recognize that these restrictions are an interference on the freedom of assembly, and therefore they must be analyzed according to the 3-part test that we discussed. the three-part test that springs from the International Covenant in Article 21. In other words, the limitations must be necessary and proportionate to a legitimate government purpose. It must not interfere with the message, that is, the restrictions must not interfere with the content or the message that the Assembly is seeking to convey. Ideally, the restrictions should not place the Assembly outside the range of the target audience. The Assembly organizers should be within sight and sound of the target audience. So a restriction which would require an assembly to be held on the outskirts of the city rather than in the central downtown area may indeed violate international principles if it places the assembly outside the range of the target audience. More disturbingly than time, place, and manner restrictions, some governments will place prohibitions on public gatherings, bans on assemblies. Blanket bans are likely to be disproportionate under international law. It would likely be difficult to meet the three-part test, particularly the necessary in a democratic society prong of that test. There is almost certainly going to be a less intrusive means available. If not, then the prohibition, the ban, becomes a measure of last resort. But again, this is something that needs to be analyzed on a case-by-case basis under the three-part analytical test. There are certain grounds for restrictions that governments may rely on that need to be looked at very closely. The disruption of traffic, for example, is a fairly common reason for prohibiting an assembly or limiting an assembly in some way. But that is not a legitimate basis for doing so. There is a recognition under international law that traffic disruption or disruption of ordinary life is indeed likely to happen with many assemblies and is not a ground in and of itself for prohibiting the assembly. A hypothetical risk of public disorder, the presence of a hostile audience, the possibility of minor incidents of violence, all of these grounds are not sufficient to impose restrictions. There must be something more that meets the three-part test. Picking up on that theme, it's important to emphasize the access to public space issue relating to freedom of peaceful assembly, and the fact that, as the Spanish Constitutional Court put it quite eloquently, in a democratic society, the urban space is not only an area for circulation, but also for participation. And this gets at the notion that public space is not just for the movement of traffic or the movement of pedestrians, but also space for public gatherings, for assemblies, for raising issues of public concern. Inevitably, those two things, circulation and participation, may conflict, but that conflict in itself should be managed by the state. The state has a responsibility to deal with that in a way that does not result in a prohibition or undue limitation of the assembly. Moving from time, place, manner restrictions to content-based restrictions, we note that international law is very clear that there should be no restriction on the content of the message being conveyed, subject to Article 20 of the International Covenant, which refers to incitement to violence and hatred. Beyond that, there should be no restriction on the content of the message being conveyed, so that messages that are annoying, that are offensive, are still protected. Political ideas are especially deserving of protection, and criticism of government among them is also protected. The European Court put it this way: in a democratic society based on the rule of law, Political ideas which challenge the existing order and whose realization is advocated by peaceful means must be afforded a proper opportunity of expression through the exercise of freedom of assembly. What responsibilities do organizers have? Well, there is a responsibility to make reasonable efforts to comply with the responsibilities they've been given in terms of organizing the march. But there should be no liability for unlawful actions of individual participants, for the unlawful actions of non-participants, or for the actions of agents provocateurs. The principle of individual liability applies, and organizers should not assume liability for the unlawful actions of others. That's critically important. Secondly, there should be no financial liability for the provision of public services. That is, if police services are required to keep order, if medical services are required for participants in the march, if cleanup services are required after the march, those services should be provided by the government. It is their duty to do so. And there should be no financial liability placed on the organizers. Doing so would be a significant deterrent to the freedom of peaceful assembly. And we close by looking at the duties of the state, which we've been speaking of throughout, both a positive duty and a negative duty. A positive duty to actively protect peaceful assemblies. This includes the protection of participants in the assembly from any persons who might attempt to disrupt or inhibit them. It includes the protection of participants in the assembly from a simultaneous demonstration. Where there are simultaneous and opposing demonstrations, there is always the possibility of violence and disruption, and it's the state's responsibility to ensure that that both demonstrations are able to go on peacefully. It is particularly important when persons are holding an assembly relating to some unpopular view, and this is something that the state again has a responsibility for ensuring their safety from perhaps angry crowd viewers. In addition to this positive duty, there is a negative duty to refrain from interfering with the freedom of peaceful assembly. And this, again, is something we've been talking about throughout. The state should refrain from prohibiting assemblies, from placing severe limitations in terms of time, place, and manner, content-based restrictions, from excluding certain categories of persons, such as non-citizens and so forth. All of those interferences would need to be analyzed according to the International Covenant three-part test to see if they could be deemed justifiable and to see if they are appropriately proportionate to the aim pursued. I will finish by referring you to some resources. ICNL on its website has a thematic portal available on the freedom of peaceful assembly, and I would urge you to take a look to see a fuller range of materials. To highlight just a few, there are 2 reports from the UN Special Rapporteur on the freedoms of peaceful assembly and of association. One was issued in April of 2012 and one in May of 2013. Both of those reports address good practices relating to the freedom of peaceful assembly. And indeed, much of the material I presented to you was drawn from those reports. In addition, there is a report called Defending Civil Society, which ICNL co-authored with the World Movement for Democracy. And the Defending Civil Society report, among other things, articulates international legal principles relating to civil society broadly, and includes a section on the freedom of peaceful assembly. In addition, the OSCE has prepared guidelines on the freedom of peaceful assembly, and those are also available online. Thank you very, very much for your attention.